just we had a little bit of a glitch, so I'm just shooting over a link to Tim, and it'll take 1 second. Okay. So Tim had a hearing today for a client in his work, and I know he was off site, so here he is. Okay, hi everybody. Glad to see us. See a lot of familiar faces, and we're just getting started. And today, you know, our topic, it's a pretty good topic in terms of MCAS. It's something that's been plaguing us for years, ever since MCAS got established, and folks graduating early and getting stuck in terms of services. Hey, Tim, how are you this morning? I just emailed it to you too, and you probably got it on your own, it looks like, but great to have you with us.
Good
and I was just
here.
telling people about a hearing this morning, right? So,
yep.
And I'm trying to think, Tim, we've known each other for years. I'm trying to remember when we first met, maybe even prior to DLC, but I'm pretty sure it was at Disability Law Center where we actually had substantial work together. And,
I think that's right. Back in the mid-90s.
Wow. Wow. Geez, huh?
Yeah, exactly.
So I was saying, it was when I came here, like it was Richard Howard, right? Eventually you and Dana Hearn, right?
Mm-hmm. Yes.
And of course, you know, plenty of other people around you guys and after you as well. So, and Rick Glassman's been there for a while now, along with Hillary Dunn and other team members, and depending upon what we're talking about, right? So everybody, welcome today. Tim has had like an unbelievable record, especially in all areas of disability, by the way, and probably other areas beyond disability that I don't necessarily know of. I'm letting people in as I'm talking.
Sure.
But specifically, you know, starting in the mid-90s or so, when he became attorney at the Disability Law Center and was also involved in policy issues with us. And so not just in the court process, he was an important colleague that, you know, we would talk about situations and strategies. And I'm gonna make sure my phone's off. And then after that, he went into private practice. I'm pretty sure straight from there, if I remember right. And it was great to know he was out there. I would refer him people sometimes, you know, and then more recently with COVID, right, with the work that you were doing, SPAN, MAS, and other organizations, and we got to work together again around this for students. You were focusing in that area, you know, and folks through 22 and accommodations, and you were like the expert we go to get input. So it's now you're, you know, why don't you tell people a little bit about your new gig? You closed the private practice down. I don't think you're slowing down at all, though.
Maybe just the opposite. Yeah, unfortunately. But no, I had, you know, I started my legal career as a public interest lawyer, and I'm ending it as a public interest lawyer with a sandwich of a little bit of, I guess a little bit, 20 years of private practice in between. But I was really fortunate. I got invited to join the EdLaw project, and the EdLaw project is a entity that's a part of CPCS, the Committee for Public Counsel Services, which provides most of the public defender work in the state, represents people in criminal cases, represents people in mental health cases, and represents juveniles throughout juvenile court. And what the EdLaw project does is try to provide as much help as we can with regard to special education and discipline and other education matters for those kids who are involved in court proceedings, whether they're delinquency charges or CRAs or abuse and neglect or other involvement that you might have through juvenile court. So it's a great opportunity. I'm working with some really great lawyers, and you know, hopefully we're going to try and change the system. The EdLaw project's got a really unique facet to it that has me really amazed, and that is, you know, we have something like over I think 3,000 court-appointed attorneys throughout the state and involved in representing students. And if we can get them involved, not just in the court matters that they're appointed on, but in the actual education matters, and we're doing that, then we've recruited a huge army of people to change school systems. And so that's
and you're going to have a lot of backup information, aren't you? You're going to have data with 3,000,
right.
just the multiplier effect. Wow. So they all are involved with youth in some way, all those attorneys?
Mm-hmm. Yes.
Now, many of them are part-time, so your challenge is going to be getting their attention, correct?
You got it.
You got it.
and getting them to want to do this, and a lot of it is, we're working with them. Sometimes we'll take a case over for them, but hopefully, again, ultimately, we'll have trained all these people, and they'll have this knowledge. And the one thing that we know for certain is that there's still, despite the fact that in Massachusetts we have a pretty good wealth of attorneys who are doing this kind of work, we still don't have enough resources, particularly for low-income individuals and middle-income individuals.
Right.
No,
and we face that, in our advocacy, where, we try to connect, right, with many groups and get, because we know what we do comes alive in personal situations, right? It
Mm-hmm.
comes alive in people's experience and the supports they get. And if we can't, if that doesn't get actualized on the ground, it doesn't exist. So, how do you help those attorneys appreciate that? And how do we help families appreciate that? And how can those leader families in low income or low middle income leaders, the leaders that are there are many, how do we get them connected with the folks around them and connect to the ARC? Or in your case, EdLaw, or whatever it might be, people that are trying to change things and make them better. So I'm excited for you, Tim. I think that's great. And again, so welcome today. And I'm going to hand you the ball for a while, give you the presentation, or do you want to just walk through it? How do you want to do it?
If I do have a little PowerPoint here that might help serve, and if I can get it up and running, there's always those issues.
I think you should be able to do it without me authorizing you, but I'm looking right now to see if I have to authorize.
I think so, and
Okay.
And I think I just need to get this thing going.
Great.
So let me just tell you, what I'm hoping to do here. One of the things that's happened as a result of the pandemic is that there is this kind of unexpected result of students exiting special education earlier than they might have otherwise. And what I want to do today is kind of walk through how that's happening and what can be done for families that are facing this. And this is, the second year that this is a problem, and the problem is because of the MCAS waiver. But we'll get to that. So let me just kind of start by looking at some issues around students getting older in special education. First of all, I think most people are probably aware of most of these provisions, but when a student turns 18, under law, under IDEA, they become an adult. They become the person who gets to sign IEPs, who gets to make education decisions, unless there's a guardianship. And there are ways of being able to delegate that responsibility through the IEP process, or to share that ability. But it is something that parents need to be made aware of. And unfortunately, I still see a lot of people who are kind of blindsided by the fact that age 18 comes and all of a sudden they can't be the sole signatories on IEPs. And so just in terms of planning for this event, you want to make sure that you are thinking about it. And if you are the parent of a young adult who has competency issues, you need to be talking with someone about guardianship. These days, many families are able to do that on their own. There's a lot of attorneys out there. DDS still is doing these on behalf of some people. But you want to have started that process, so all of a sudden you don't show up at an IEP meeting on or about your child's 18th birthday and realize that you can no longer sign the document a loan, and if the student is going to have problems in signing a form delegating a responsibility, this is going to be an issue.
Hey,
So,
Tim, can I ask you a question on that? Is there
yeah,
another level besides guardianship that people can do that allows them to continue this if they do it in advance?
yeah, I mean, essentially, again, the law does allow a student to delegate responsibility or to agree to share. There's a form that gets signed. In Massachusetts, unfortunately, the school districts insist upon that form being signed in the presence of at least some school personnel. I've tried to do this with powers of attorney and had mixed success around that issue. Of course, in order to do a power of attorney or to do a delegation, the individual needs to be able to do that. Needs to
Right.
understand what it is that they're doing. So, we are making a lot of progress around shared decision making and in general, and hopefully someday we won't have guardianship, or it won't be as common as it currently is. But again, this can be an issue that's approached when families are doing that planning around shared decision making. It's not just shared decision making for living decisions and working decisions, but it's also
Right.
for school.
So we really need to pass that damn supported decision-making bill as soon as possible. So we can have, so
Exactly.
your point is really that absent that, and then in the context of that, environment, sometimes people discourage this, might unintentionally or intentionally discourage the student because maybe the student will graduate early and make decisions. And I know that's happened anyway, where there's been conflicts, right? Where the student isn't necessarily thinking ahead at that point, right? They're just thinking of graduating. And
Sure.
so, all
Yeah,
right, I'll let you
exactly.
go. Yeah.
Yeah, no, it's a good point. And again, I mean, there needs to be careful thinking and discussions within families about these issues early on and before the age 18. But again, other issues that we need to look at when we're approaching the end of special education is transition planning. And I think that there's been a lot of discussion and a lot of presentations, and most people are familiar generally with the principle of transition planning. And I think we're getting better and better at it as we go along. I mean, I do have to say, going way back, I mean, this has been a provision in IDEA, not since the beginning, but since the mid-90s. And for a long time, Massachusetts has not been compliant with this aspect of IDEA. We kept getting cited over and over again in the federal annual inventory of whether the state's in compliance with various provisions of IDEA. I think we've put an awful lot of energy and attention, and we're moving in the right direction, and we no longer are being cited for being out of compliance. But it's still a work in progress. The one thing I've learned over the years is that it takes years to enact changes within institutions like school systems that are so bound by bureaucracy, and that's the way we do it, and those types of things. So it's still not great, but certainly we're seeing a better approach. We have a form that people should be familiar with that starts getting attached to the IEP beginning during the IEP planning for the year that the student turns 14. It asks some basic questions. Interestingly enough, even though we see it attached or submitted with the IEP form, technically it's not part of the IEP. There have been decisions by the Bureau of Special Education Appeals which say, well, this is a planning document. You don't have to really comply with it. Failure to comply with the transition planning form does not necessarily mean that there's been a violation of the right to a free and appropriate public education. Those are kind of unfortunate decisions. Some of them are in the process of being reviewed by courts, and so we may have ultimately different decisions about them. But it is at least a planning system. And I would say a couple of things about transition planning. Planning can only be as good as the tools that you're working with for planning, obviously. And one of the fundamental tools that you need in order to engage in constructive and effective transition planning is an assessment of what the student needs. You know, we can all sit around the table and think of a lot of things and brainstorm, but there are now very well-trained and experienced professionals who can come in and using a combination of both standardized and individualized assessment tools, come up with a very good supportable framework for the kind of supports that a student needs to realize the goals of IDEA, which are independent living, work or education, and participating in society as everyone else. And so we're certainly aiming in that direction. Those are the great general goals of IDEA. So if you're not already involved in the process, make sure that you are. And like any other kind of assessment, these can be done by schools and they can be done privately by other individuals. Generally, you know, my recommendation is beginning sometime around age 14, 15, or 16, to ask the schools to conduct a transition assessment. And that should help guide the team and then looking at what kind of services need to be provided for the remainder of the student's entitlement to special education. You know, if like any other assessment, if the parent disagrees with the transition assessment done by the school district, and if it's not comprehensive and complete and accurate, the school district can be ordered to pay for an independent transitional assessment. So these are no different than psychological assessments, academic achievement assessments, speech and language assessments. There are similar instruments, and you know, you should exercise your right to them, because this is, you know, ultimately the most difficult part of special education, at least for me. I think, you know, the ARC has recognized this in, you know, knowing that this transition to adult services is fraught with a lot of uncertainty, with a lot of difficulty for most families. And having the support brokers is a great asset that helps people make those transitions into adult services. But it really should be beginning in school, beginning at the beginning of high school, and continuing thereafter as long as the student remains eligible, which, you know, may be 12th grade, it may be age 22, it may be someplace in between, and that's what we're going to get to here in about 2 seconds, I think. One other thing about transition planning, I mean, well, we'll skip that definition. So let's go to, when are you done with special education? And I think this has been an extremely difficult question to answer. It's extremely thought-provoking, it's emotional, and there's a lot of conflicting information out there about this. But you know, one thing we can say for certain is in Massachusetts, it's age 22. Interestingly enough, you know, in Connecticut, it was age 21. There was a lawsuit brought. It's now age 22 as a result of that lawsuit. But we know that 22 is the upward bound of when Massachusetts recognizes the right to an education. Some states have the right to education to age 25 or 26. We don't, but this is the one kind of firm guideline we can look at. But students can be terminated from special education earlier than age 22. In order to terminate a student from special education, there's a process that the team has to go through. So it's not just a decision of the principal or the administration or looking at grades, but it is a team decision that needs to be made. And this is all reflected in an administrative advisory I'll post later in the chat that came down from the Department of Elementary and Secondary Education, I believe in 2018. And what the department did in that advisory is essentially do some research, look at some of the case decisions that have been out there, and try to formulate exactly what the law is, which is always difficult, and particularly in this area where it has been quite confusing. But essentially, this advisory says Okay, you're done with special education, either at age 22 or when you graduate with some additional caveats. Let's talk first about what it means to graduate. In Massachusetts, what it means to graduate means that you have completed the local school requirements for a high school graduation. And for most school districts, that involves 4 years of high school English, 4 years of high school math, some kind of science requirement, some kind of, in some cases, language requirements, although those can be waived. A lot of school districts have obligations around community service, but the local school district has created its own set of criteria towards graduation. In addition to that local set of graduation criteria, which may vary from school district to school district, the state has set one big standard for graduation, and that has been achieving a minimum score on the MCAS in both in three things, in ELA and in math and in science, technology, engineering, STEM. So the MCAS has been, for most students, the most significant challenge to graduation. The MCAS scores that are set by the state, set by the Board of Education, reviewed on a regular basis, demonstrate a minimum competency in those three subject areas that are felt to be necessary to reflect the fact that the student has accomplished what we want students with a high school diploma to meet. So that can be a significant barrier for students with disabilities, and they have a lower rate of passage of the MCAS. In addition to the ordinary pencil and paper MCAS, we also have, for students with disabilities, the ability to take the alt MCAS. The alt MCAS is still the MCAS. It is still the same basic requirements of demonstrating certain proficiency in ELA and math and in science, but it is recognizes that some students with disabilities may have difficulty in demonstrating that competency on an ordinary paper and pencil test, and they are allowed to demonstrate their proficiency through other means, submission of work in a form to address the specific standards of the MCAS. Now, for a lot of people, the question of alt MCAS versus pencil and paper MCAS can be, again, an emotional decision. And the one thing that I've found is that, unfortunately, school districts seem to be erring on including too many students in the alt MCAS as opposed to what they should be. The United States Department of Elementary and Secondary Education, the United States Department of Education has said that less than 1% of the students on special education should be taking alternative tests such as the alt MCAS. The remainder should be able to accomplish pencil and paper. We're at a much higher percentage in Massachusetts than that right now, and I think it's based upon some misunderstandings in school districts. I think a lot of school districts think that if they have kids on the alt MCAS, they're not going to be subject to the same accountability standards that they are generally for the MCAS, and how that might affect whether the state comes in and intervenes in the school. So that's something to keep in mind. But again, it's not the principal issue. What I'm here to talk about today is the fact that the state has all of a sudden eliminated the MCAS as a requirement, or perhaps eliminated isn't the correct standard. What they've done is they've made a substitution saying you no longer have to achieve a score on the test for the school years of 2020 to 21 and 2021 to 22. Now, after this June, we'll go back to having to pass the pencil and paper MCAS or having to get a sufficient score on the alt MCAS to demonstrate proficiency in order to meet the state requirement of graduation. But all of a sudden, that's gone. What does that mean? Well, for a lot of students with disabilities, we've known that they're not going to pass the MCAS. We've seen that for over the years, and we've kind of come to expect that, and we've planned accordingly. And these students usually remain in an educational program through age 22, unless they can pass the MCAS sooner. Now, we probably have all seen students who, retake the MCAS, retake the MCAS. You can continue retaking the MCAS as many times as you want to try it. And many of those students do achieve. And part of that's because of the design of retaking the MCAS. It's slimmed down, it's modified. Schools are able to teach more to the retest, and so there's a pretty good success rate with retesting, but there still remain a substantial number of students in the state who aren't going to achieve proficiency on the MCAS scores. So all of a sudden, those students are getting high school diplomas, which is a good thing, but people don't realize that getting that diploma generally means that it's the end of special education. When I say generally means, you'll see on this slide that I have some of the additional criteria that the team needs to look at in determining whether a student should be graduated from school. And those considerations are whether the student has made progress on some goals, whether the student has been provided proper transition services, and whether or not the schools follow the right process in coming to this decision. Now, a lot of you may look at this progress on some goals and wonder what that means. And of course, that's what I wonder. So, I have to go out and look and see, what do the courts say that this means? And it's not that the student has met all the goals and objectives on their IEP by the time that the team is proposing graduation. It is, as the courts make clear, progress on some goals. So it's generally the cases that I've seen that have challenged whether or not this determination is proper. The courts found that progress on 2 out of 7 goals and some progress, not achieving those goals, but progress towards them, as indicated by progress reports, assessments, and other information, may be sufficient to meet this requirement of IDEA with regard to graduation. The next provision, the proper transition services, again, is interpreted pretty broadly. It is not a complete barrier to moving a student out of education, but it is one of the considerations that the team needs to take into account. In addition to it perhaps being a way to delay graduation, if a student has not been given proper transition services, the student may have a claim to compensatory transition services, even if they're graduated, even if that decision is made. In Massachusetts, you can bring a claim for compensatory services. And we're talking the general compensatory services, not the COVID compensatory services process, for up to 2 years following a decision. And the courts have decided in Massachusetts that graduation is not a barrier. So if a student graduates at age 18, they have until age 20 to go back to the school and say, hey, you didn't give me proper transition services. Many of you are probably familiar with a case called Retakes, which was a case brought by the Disability Law Center around proper transition services. And it was one of the first major decisions by both the Bureau of Special Education Appeals and then subsequently the courts around what proper transition services meant. And then Retakes, the hearing officer at the time was Bill Crane. He was a great hearing officer. And he found that Retakes had not met the student's needs with regard to transition services and ordered that they provide some additional services post-graduation. The student did get his diploma, and the student went on to receive some services following the award of the diploma. And that decision was generally upheld by the court. there's a little bit of back and forth into it, and it wasn't entirely upheld, but for the most part, the court did recognize that the failure to provide these services when they should be provided gives claim to compensatory services. And finally, I want to come back to proper procedure. With regard to proper procedure, what we're talking about is that this is a team decision. And this is where I think it's really important, and why I wanted to talk to people about this topic, is that unfortunately, we saw last year several situations where school districts took advantage of the MCAS waiver to push kids out the door who would not otherwise have gone out the door because they had never passed the MCAS, weren't going to pass the MCAS, and weren't students who anyone had thought would be leaving early. And so IEPs never addressed this issue that, 12th grade, you're gone. So proper procedure means that the team has been considering graduation date. Now, this is kind of sneaky. There's not a clear place on the IEP where this information gets published. Usually it's found under additional information towards the end of the IEP, and it may simply be a line that most of us don't even pay attention to. We don't think about it. The anticipated graduation date is June 2022. Well, what does that mean? We're so tied up in making sure appropriate services are being provided and all of the issues involved in getting through high school that you don't think about, the school's been saying that the student should be done in June of 2022. So when the MCAS waiver was announced, the state issued another administrative advisory. I'm sorry, this first advisory is the one that we've been speaking about. But when the state did the MCAS waiver, as part of the process, DESE put out some information, not in the form of an advisory, but in the form of instructions to schools saying that, you shouldn't be taking a student who no one had anticipated graduating and simply push them out the door in June of 2022, because you can now do that with the waiver. So they've said, again, this must be a team decision. It must be noted on the IEP. And we'll get to the next point in a second. But so what's really important is that if you are the parent of a child who finishes 12th grade in June, that you pull out their IEP and you look at that and you find, as I say, usually under additional information on page 11 or 12, depending upon how the IEP is put together and how many goals and objectives there are. If that says June of 2022, you do not want your child to have special education services terminated as of that time, then you need to reject that part of the IEP immediately if you haven't done so already. And so even if you've fully accepted the IEP when it was written back in June of 2021, you can still pull it out and send an email saying you now partially reject the graduation date. And again, the state has made it clear that this should be a discussion about this. My experience has been that there haven't been discussions. The school districts tend to automatically put graduation at the end of 12th grade on IEPs, even though they don't expect some students to graduate at the end of 12th grade. And so unless it's raised by parents, or, it's going to go by and, it's going to happen. Now, as I said, you can reject that graduation date. And if you reject that graduation date and you reject the diploma, and it's important to do both, then the school district has the obligation to continue to provide special education under the general stay put provisions of special education law until the dispute is resolved at either a hearing at the Bureau of Special Education Appeals or through an agreement. So stay put's really important and powerful here, and it can keep a student in school post an anticipated graduation, but only if you reject the date and reject the diploma. So, I just, again, want people to be, aware of this provision and, ready to take action with regard to it. As I say, this shouldn't be a problem after this June, but it continues to be a problem for this school year. I do want to make it clear that, even though the MCAS is waived, the state has said that, the schools have to show that they at least have taught a course and the students earned a credit for a course that's aligned to the curriculum frameworks in the relevant subject matter, ELA, math, science, in order to meet the modified competency determination. And actually, this doesn't apply to science. Science is just out the window for this year, it was for last year. So those decisions should be made at team meetings, and they should be challenged at team meetings if they haven't, if they've been made incorrectly. People should be looking at those things. I do want to state that in addition to this graduation issue, the state did recognize that the pandemic had extraordinarily bad results for older students who were turning 22. All types of problems emerged. We saw the inability to engage in transition programs that were in the IEP because people couldn't work, people couldn't go out in the community. There was a loss of that ability. We saw people stuck in the system, as you've discussed at these meetings here, because DDS isn't able to provide services for individuals who would otherwise be leaving special education and going to adult services. We've seen these tremendous setbacks just simply from being confined and being home and not being provided in-person instruction. So the state, when they first enacted an advisory about compensatory services as a result of COVID, specifically brought this to the attention of school districts and said, look, you've got to look at COVID compensatory services for any student who was significantly impacted, but we want you to prioritize these students that turned 22 back during the peak days of the pandemic, March 17th through December 23rd, 2020, and identify those and get them lined up for compensatory services. Well, that time is long past now. But students who have not been able to get the full benefit of their IEP over the last year because of staffing issues, because of schools going into quarantine, schools being virtual for part of the last school year, still have rights to compensatory services, and you need to be looking at those. But that right to compensatory services does have an expiration date on it. It's not December 23rd, 2020, as this headline might suggest. That was simply a directive by the state to prioritize those students and look at them first in line because they're the ones that are most likely to be affected. But there is a 2-year statute of limitations with regard to compensatory. We're approaching 2 years in about 5 or 6 weeks as to the beginning period of interruption that would justify the award of compensatory services. So if you've not successfully negotiated with your school district around compensatory services, you should be trying to do that. And if you've tried to do that and not been able to get to a point that you can agree to, you should be exploring the possibility of seeking compensatory services. There are all kinds of issues about compensatory services, and they go beyond the framework of what we can talk about here today. Part of it is, what can they be? How, what can we do? How can we put it together? Finding the right service providers. Those are all quite difficult issues. But I think that we've gotten to the point where we've got a lot of people who have worked on this issue. We've seen some good results coming out of DDS where There has been some cooperation around trying to identify an appropriate way to take services forward and carry them forward, even though the student has aged out of special education, and it continues to be a work in progress. And then I just want to say, alert you to one other thing with regard to this population of students. And this has not gotten too much attention that I've seen, and maybe you've talked about it already, but in the beginning of December, the legislature passed a huge appropriation bill to dole out the ARPA money, the American Rescue Plan Act money, that, or at least part of it, that the state received directly. The rescue plan money has had all kinds of spigots. Some of it went directly to state agencies, some of it went directly to, got passed quickly from direct agencies to school districts, some of it went directly to state agencies, some of it went and had to be appropriated. And so in this bill that was passed at the beginning of December, we had all kinds of pieces of funding out there. But one of the things that hasn't got much attention is that the legislature specifically set aside $10 million for compensatory services to adults that reached age 22 during the 2019 pandemic. Now, what does that mean? This is the entire language that the law as it is consists of. What we can tell you is, first of all, this was a transfer to item 7061-0012. What's that? Well, that's
Circuit
the account. Pardon?
Sorry, I said circuit breaker. Go ahead.
Yeah, good. You're smart. You follow the budget, but yes. So this money has gone into the circuit breaker fund. And the circuit breaker fund is this fund for extraordinary special education expenses that districts apply to the state and get reimbursed, approximately 75% of their cost over a threshold that's essentially 4 times foundation, which is about 46,000, whatever. But this is clearly not just circuit breaker money. And so there have been just some discussions at the state level about this. I don't know where those are at this point, to tell you the truth. I haven't been invited or, provided any information. I think that there was some thought that initially they might be able to do something with this similar to what they've done with the DESE DDS funding. Do you know, Leo? Have you heard anything about this?
You've got a bunch of reactions today, and I'd love to make time for that. All I want to say is we assumed this is money. We cited this a few times, that this is money the schools can access if, they cry poor mouth around somebody putting in their IP, that they require the compensatory services. In fact, the law you cited, the language, right? People have to ask for that. We were worried because they have to ask for it, people won't ask for it, right? So we were still supporting a bill that would require it, even though the legislature has told us, look, we took care of it. Why are you asking to pass the bill? So I think, so anyway, the bottom line is 10 more million is out there for the schools. It will get worked out, right? And, but you've gotten a tremendous response. So I would love to, ask you to share the PowerPoint via PDF that we could share with people, and we'll send it to all the attendees. And then Lucy started with, so there's a bunch of questions, and I'm trying to decide whether I should hold Lucy's for a minute, because there's some really specific questions, people asking about, one person asking about graduation being pegged for 2024. And she's concerned for her son. And should she be, going ahead now and questioning that, because she believes, obviously the implication here is he'll be younger than 22 in 2024. And clearly, she's asking what she needs to do, and I would think she needs to get it into his IEP, right? That he needs transition services. I mean, you laid out some transition. What I understood you to say, let me start with this, because I think that this will help people with those questions. You said the transition, I was sort of surprised, the ITP or the transition plan, that's all it is, a plan. It's not really part of the IEP. So in that case, I would think any young man, young woman, or parent should make sure elements of the ITP or the plan, I shouldn't call it ITP, that's something else, the transition plan,
Right.
should get implemented into the IEP, correct?
Absolutely. Absolutely. You know, theoretically, I mean, what the transition plan document is supposed to do is it's supposed to serve as a planning document for the IEP and for what services need to be in the IEP, what goals and objectives need to do in the IEP. The reality I find is that it rarely happens. There are very few school districts that look at the transition plan first and then talk about the IEP the way that they should be. Instead, it's kind of an afterthought. You know, something we got to do, the law requires it. We'll ask Johnny what he feels he wants to do and whatever.
Right, right.
But yeah, and in terms of the you know, the question about, you know, objecting to the IEP, I say, you know, there's no harm in doing it as soon as you can. You know, unfortunately, we get all these cases that people haven't thought about it, and all of a sudden in June, we have to seek emergency orders because, you know, they now realize that this is going to be a disaster.
Right. Good point. I am going to bring in Lucy's. She had some generic points that I want to bring up, and I may or may not be able to characterize her first point. She's saying hearing decisions now follow the required recommended procedures, not based on needs of the particular student. Is it possible to force changes to make hearings more relevant to the needs of the particular students? Is legislation needed? So is that how you're seeing it too, Tim, that they sort of, they follow the right procedures, so you're out of luck? Or, I mean, I think that's,
yeah, I mean, that,
Lucy.
you know,
Yeah.
Unfortunately, that's, I mean, I do think it would require a legislative change. You know, a lot of times, you know, parents come to me and say, you know, we're concerned our daughter's going to end special education in 4 months and she's not ready. Okay. And, you know, unfortunately, not being ready doesn't have anything to do with whether special education can be terminated. You know, if you've met the local requirements, no matter how socially maladjusted you might be or inept or how ill prepared you are to go to the next step, whether it's work or college or whatever, it doesn't make a difference as long as you've met the local requirements, the state requirements, and made some progress towards your goals and objectives, and it's been considered. So yeah, if we wanted to change it, it's not that the BSEA is ignoring students' needs, but that the law does. And the BSEA essentially, I mean,
Implements the law.
Yeah,
Let me
I mean,
ask let me ask you that another way. That if you have transition goals in there and she or he hasn't met them and she's under 22, he's under 22, isn't that reason to continue the education?
Not by itself. Again, I mean, what the general criteria is that the courts have said it would be wrong to graduate somebody who hasn't made any progress whatsoever in their special education. But as long as they've made some minimal progress towards some goals and they haven't identified them, certainly a good argument could be made. In addition, I mean, if they've failed to meet the goals and objectives with regard to transition, it's a good argument for making claims to compensatory services. And I kind of want to put those as two separate considerations. I mean, one is delaying graduation. The other is, even if you've graduated, getting some services because you didn't do the right thing before graduation.
Okay. All right. That's wow. Okay. That's new to me. All right. So, and as someone and that's probably because we focused heavily on transition and adult life here and look to SPAN Mass and FCSN and MAC, you know, and DLC for the work when they need us and on the policy stuff on kids. Wow. That's so Lucy's point does hold in terms of graduation for kids with special education needs, especially I would think for kids who are, you know, maybe not even intellectually disabled, but have special education needs who get ignored in terms of their core needs, right?
Mm-hmm.
So law would need to be changed for that to focus more on how the student benefited or not. Someone asked what the role of the district is during this transition in the school. Well, I think you did convey that, you know, in terms of, you know, identifying with the agency, right? You basically identifying the right agency for referral, correct?
Yeah, you know, but there are a lot of interesting things with regard to that. I mean, we do have 688 yet as a separate state law, and it's not IDEA transition, but it's similar in terms of this form having to go to a state agency in terms of, identifying for adult services. But, I think that law unfortunately has no teeth to it. And so the failure to make a 688 referral is found not to be fatal to
Wow.
a decision to graduate.
Wow.
I think really, if we went back and looked at the history of 688, it was largely driven by the request of the state agencies to be able to do their own budget planning. I mean, that's where DDS gets its turning 22 line.
Yeah, I mean, and we put a lot of energy because there was no money historically for kids graduating, right? So they were graduating to an abyss. And DDS has obviously been the largest, well, we worked to make it, get significant funds. Not all state agencies get those funds. And how to then, maybe we should be looking at the school side of this, huh? Is what you're saying a little more.
Sure.
What about, someone asked, wow, there's a lot here. When a parent rejects the diploma, should the student take the MCAS again next year? What if they do not pass?
So once a student's taken the MCAS and failed, there is no obligation that they have to continue taking it. And that's entirely a decision that the family makes. If they really are looking for a full diploma, not a certificate of completion, then the student should continue to take the MCAS. And usually there are at least two periods each year where you can retake the MCAS. And, as I said during my presentation, some students do pretty well because the retakes are slimmer and, schools can work at it. I worked with one young man who had an ASD diagnosis and some intellectual disability. Math was a real problem for him, but the school worked with him. I think it might have been the 6th or 7th administration, but he passed the MCAS.
Wow.
So you can keep going, but you're under no obligation to. So if the students failed to pass the MCAS and the parent wants to keep the student in special education, that decision can be made and without any worrying about anything further. Once you've failed it, you should be able to stay in, unless you're in this 2-year window of waiver that we are.
So one parent has shared that her daughter, unfortunately didn't get her past MCAS. She really would love a diploma. She's 31 now. And she basically, her mother doesn't think she could pass a GED. It seems harder for her than the MCAS. Maybe because it's broader, right? Covers more territory. I don't know. I do know some organizations that do help people with actually ID. And I know LifeWorks used to for years as the Arc of South Norfolk. I don't know if they're still doing it. But what do you think? Is there any vehicle for someone who's obviously, if they're still in or they're within 2 years graduating, they could ask for an accommodation, right? And figure out a way to make a portfolio, right, to pass the MCAS. But her opportunity to do that is passed. Is there any other way she could get it?
No, I don't know of any way except what was formerly the GED and now is high set. And I think that there are a lot of programs that do tutor and help people get this. My experience has been that many students do actually pass the high set that did not pass the MCAS. And it might be because of the specific tutoring. It might be because you can take sections. You can pass one section, come back, take another. It can be a lifetime goal. The accommodations do have to be provided for that test that are substantial. So,
great. So there is more flexibility than this parent may realize that could help make that happen.
Right.
Okay, great. And then someone else, these are getting really specific, folks. I'm going to do one more specific, but I'm not sure. This is really fine-tuning Tim here. So somebody turned 22, July 2021, while on a CCS plan. And basically, bottom line is they removed independent providers saying she turned 22 and that her rights are gone. I would think she would have had that plan for a couple of years, no? given COVID, July 2021, I guess the emergency was what, March 2020? Right? We're approaching 2 years now. So maybe they felt obligated to only do it for a year and a few months. But fall of 2021 that they stopped some of it, removed independent service providers. Yeah, that seems early. It's only a few months after she graduated, July to fall, right?
So, the thing about compensatory services is that it's not a one-for-one makeup as we would like. And the state has said that in their guidance. And unfortunately, the cases say that in general about compensatory services. So what is it? And it's like anything else. It's what you can prove is needed to make up for the loss. And, I would say that, my guess would be perhaps in this situation, there should have been a specific agreement about what the school district was going to be providing for compensatory services. We're going to do 100 hours, we're going to do 200 hours, we're going to do 5 hours, whatever it might be. And if that has been reached, then it's over. If that hasn't been reached and they've terminated it, they've probably violated actually essentially a contract. And so there are various ways that you could go about enforcing that. But if they had reached the limit of what was agreed to in the plan, then you're probably at the end of the obligation of getting the schools to do anything.
So you need to get them to be really specific, right?
That's
Document that in writing in the plan itself. That's signed off. Okay. And then Kathleen Amaral shot me a link at DOE or DESE, I should say. It would still use the DOE website though.
Yes, right.
Yeah, but so I shot that out to everybody. Thank you, Kathleen. Good. And then Tabitha, thank you. She said a lot of schools don't do 688 referrals, especially for students with autism. And it seems, so especially if they graduate before age 22. So she's noticed. So that's interesting. And that makes sense, probably. Not makes sense, it's wrong. But
sometimes the devil's in the detail. If you look at 688, it actually talks about having to make referrals only for students who are disabled in such that they meet the Social Security disability standard. So a lot of these students do not meet that standard and don't have an entitlement under 688 to the referral. So that's probably what's happening in those cases, kids who are going on to college. They still should be doing it. In fact, the state has made it clear. The State Department of DESE did issue a directive saying, make these referrals and make them early to DDS for students on the spectrum, because they need to hear about these kids and they need to start planning for them. And that's, a major area of advocacy that needs work.
And I'm going to do two more. One's from Stephen that I think is a good general question. During the 2019 novel coronavirus, the fact that they use that term, does that mean anytime during the current pandemic? And I would think through the emergency period, right, Tim?
That's one of the questions, and nobody knows yet. Again, the state is thinking about this. I think that they've pulled in a lot of people. Certainly, I would say that it would be as long as the emergency period, if not longer. I mean, as long as it has continued to interrupt people's services, it should be effective.
Yeah, so you would make an argument. I agree. That's a great point. I'm saying during the emergency because that's pretty black and white. But your point is, but services are still somewhat disrupted. So why not? So people should bet on that. I know it's not just during the 2019 or 2019-20 count, school year.
That's right.
Just to be clear, it's for sure that would be not the way to go. And then one last one, and then that's going to be it. Actually, one of my staff is saying, could we do a webinar? We're actually going to do a webinar with Kathleen Amaral and Melanie McLaughlin next month. Tim and I had talked about this. So actually, that'll be good for CPACs and advocacy with CPACs. And Ellen, maybe we'll do a part 2. So great suggestion, Ellen DeVernon. Boy, got a great
just
team
came
here.
up in my school district And I talked
Yeah.
about it with Kathleen, doing something
Yeah,
like
so
that.
we're just trying to nail a date down for that one, for the issues that keep coming up, different issues. And then I think talking about the importance of CPAC advocacy is part of that, or maybe even having that a part 3 in April, you know? So, let me get back to the last one. So, oh, come on, where was it? Someone had a great, yeah. So Iona, she said, with regard to CCS, if a team uses subjective data to deny it and the evaluation show lack of progress, should a parent use procedural safeguards? And I would say yes, but given what you've just said about those damn procedural safeguards, I don't know how effective that would be, but go ahead.
Yeah, I know. I mean, it's a good question. I mean, and the question is what procedural safeguards? I mean, you know, there are 3, obviously. Once you go to PRS, once you go to the Bureau for a hearing, once you go for mediation. PRS, we are seeing decisions come from them that say, you know, we're not going to look at the substance of the decision. As long as they follow the procedure, that's fine. That's PRS. BSEA and mediation are probably more likely. And you know, BSEA, expense, delay, trouble, all those, you know, downsides of it. But ultimately, you know, most things do get resolved. And mediation, I think a lot of people are seeing effective results in mediation. You know, right now, school districts, as you pointed out, or somebody pointed out, are flush with money. And what I've found is it's not so much a problem getting them to spend money, but to identify what to spend it on, and coming to the table with a firm plan, saying I've got vendors that will do X, Y, and Z. Usually will result in you getting an agreement for that.
So I'm going to reach out to our colleagues and see if there's any help we can give. Lucy was saying maybe we should, I don't want to get our own position on it, but if the other groups need a hand to nudge on that money distribution. And I mean, to me, like what's more important than money distribution is the issues you just laid out and the things that we're hearing about, you know, through the many chats that pop through here today. And it just is a shame, you know, it's obviously I always seen the school stuff, not perfect by far, right? But sort of in a place different than adult services and the challenges trying to get that resolved. But I can see where, you know, with COVID, it's really upset the apple cart even more so.
You know, what we'd really like to see with the $10 million is that it, you know, again, look like something like the DESE DDS, not where people have to prove anything to get it, you know, simply saying, okay, and we're not talking about that many students that are affected, probably someplace between 1,000 and 2,000 total that fit into that category, and students still receiving services during those years. So why not just divvy it up and get it out to families and let them use it effectively to do what they can?
You know, and that's a great idea because those dollars typically aren't federally reimbursable anyway. So you don't have that problem, you know, the state worrying about getting the feds to match at 50 cents.
Right.
So great point, Tim. So Tim, this has been great. Look for, I'll get the PDF out to people. I'm really, you know, this pretty intense, great information. Folks, thank you for coming, and great work with the EdLaw project. I'm really thrilled to hear about that. I'm really excited about the potential. Hang in there on that, getting to those damn lawyers, but you'll get to them. And even if you get to 20% of them, you're going to be doing pretty damn good. So good luck with that. And everybody, good luck with your week, and look forward to seeing you next week, where the topic is going to be the state budget and what we're asking for. I'm going to walk through it slowly. And then 2 weeks after that, Ellen Taverna and Morris Sullivan will talk about advocacy on that during the March 9th reception. So Tim, take care. Great seeing you, and everybody else.
Okay. Thank
Have
you.
a good one. Bye-bye.
Pleasure.